Welcome viewers to yet another session on the course on Media Ethics and Laws. If you are a student of EGNOU, then today's lecture is about Unit 7, Media Laws and Regulatory Frameworks, specifically for journalists, of your course MJM025, which is your course on Media Ethics and Laws, which is a part of your MAJMC or PGGMC. However, if you are not a student of IGNOU and if you've logged into this video today to gain some journal knowledge, then I assure you will not be disappointed, because today we shall discuss some basic laws which though apply to journalists specifically but are also very important for us as citizens of India. Let me begin with Unit 7, which is Media Laws and Regulatory Framework. We will begin with the need for media laws and regulatory framework. Press Registrations and Books Act of 1867 will be discussed. We'll go on to discuss the Working Journalists Act 1955 and the Press Council of India 1978. You shall know the objectives and functions of the Press Council, the powers to censor, and what is meant by ombudsman. The need for ombudsman, functions of ombudsman will be discussed. Then the Indian Penal Code and Criminal Procedures Code, specifically sections relating to journalists 124A of IPC and 153 of IPC will be discussed, and then we shall go on to look at some of the professional bodies that ethically and regulatorily govern the journalists of the country. Actually, the media are expected to serve the society effectively and efficiently in areas such as social awareness, educational development, cultural regeneration and political empowerment. Therefore, with a view to discharge these functions and fulfilling national aspirations, it becomes imperative for the mass media establishments to ensure that they perform their duties within the law of the land. Friends, in this unit, we shall discuss the legal obligations and regulatory frameworks prescribed by the government and professional bodies for journalists and media persons in India. So while you are the fourth estate once you work as a journalist, you are also a human being. While you have certain privileges by being in your profession of journalism, you also have certain obligations as a citizen of India. So between these two, we discussed in block 1 that it is your ethics, conscious regulations that guide you, but in block 2, we are looking at the laws of the constitution that you have to abide by compulsorily, mandatorily. With this basic introduction, what can you expect out of this unit? After going through this unit, you should be able to describe the important provisions in the Press and Registrations of Books Act, explain the important provisions in the Working Journalists Act, analyze the role of the Press Council of India Act, appreciate the need of ombudsman in a media organization, discuss the clauses of IPC and CPC that are applicable to the media persons, and you should also be able to mention some of the professional bodies that help the working journalists do better in their field. Sometimes these bodies safeguard the journalists and sometimes they keep them on check. So these are the learning outcomes that you can expect from this unit. But why should media persons be familiar with media laws at all? Because we are after all media people, we have the privileges, we have the duty to serve the public, so we should report whatever is applicable, beneficial to the public. Why the laws for us? Why the regulatory framework? What is the need for media laws and regulatory frameworks? Actually, there should be some of the laws and regulations which keep media persons at bay. And as media persons, as the future journalist, you should be familiar with some of them, because I shall repeat to answer this curious question in your mind, the same thing that I keep saying. You are citizens of the country first and journalists only after that. You are responsible for the security, for the peace, for the upgradation, for the respect of your national symbols, of your nation, of the preamble of your constitution. To safeguard all this, as humans, you should be familiar with these laws, and as journalists, it is much more important to know some of the acts, some 4-5 acts that we shall discuss today. Media laws and regulatory frameworks, there is an importance to understanding these laws, and let us look at the overview of the key regulations and acts that govern the media in the industry. Let me build the case further. Why media laws are necessary? To ensure accountability. Holding media outlets accountable for their conduct, for their content, for their context is important. Protecting rights, safeguarding freedom of speech while protecting individual rights. The media laws help us in maintaining standards. They ensure ethical standards in journalism. National security, preventing the spread of information that could harm national security. And public order, managing the impact of media on public perception and behavior. This is why we all need to study the media laws. After each argument that I give you, I will give you a case, which is a case study, which is the case of the real judiciary in India, which will put the point more in context for you. Like, why do we need the media regulations and laws? Let me put this point across with the case of the Times of India versus State of Tamil Nadu, which is a case of 2007. This case highlighted the need for media laws to address issues related to the rights and responsibilities of the media. It involved a dispute over media reporting and the need for regulations to balance press freedom with responsible journalism. Now, as a teacher, I am just throwing a bait to you. I have given a reference of this case. Please go ahead, pick up a media book or go to the internet and read in detail about this case so that you have better knowledge and you understand these concepts in a more rigorous kind of a manner. And I promise you that you will enjoy the concepts more when you go into the detailed study. And let me come to the next thing, which is the first act that we are going to study in this unit, the Press and Registration of Books Act 1867. Again, 1867, like the Official Secrets Act that we did in the last unit, it is much before the independence that we got. The purpose of this act was to regulate the printing of the presses, the newspapers, books, to regulate all of them. Press and Registrations of Books Act of 1867 was enacted. There are registration requirements as per this act, mandates the registration of books and newspapers with the local authorities. Owner identification, this requires identification of the printer, publisher and the owner. The historical context is, it is one of the earliest regulations which was aimed at controlling the press during the colonial era. But why do we have this act till today? Because even if we are not a colony and we are an independent nation today, something remains same, that is safeguarding the security of the nation and the public order. So whatever you publish, you are bringing it out in the public. You are liable to maintain a public order, not to hurt somebody's communal feelings, not to entice riots. So Press and Registration of Books Act comes into this, and an extension to this would be the online acts, because these days a lot of publishing of the content is happening online. That is discussion for another day. A case to put this act in perspective, the Indian Express versus Union of India case of 1985. This case involved a dispute regarding the registration of the publication. It emphasized the role of Press and Registrations of Books Act in ensuring that all publications are properly registered, providing legal framework for accountability and authenticity to journalism. If this case seems interesting to you, then friends, go ahead and read about it, gain more knowledge. Let me come to the next section of this unit, which is the Working Journalists Act of 1955. It deals with employment terms, wages and benefits, job security, leaves and hours. So, Working Journalists Act of 1955 sets standards for employment and working conditions of the journalists. It established wage boards for journalists' remunerations. It also provides protection against arbitrary dismissal, and it specifies working hours, leave entitlements and other employment conditions of working journalists. Friends, in every profession, we need to be careful about that somebody is not getting exploited. They are getting the minimum benefits of being a human, even if they are working, be it factory workers, be it journalists, be it teachers, and these days, be it even the homemakers or the housewives. So the working terms for domestic workers, for everybody are put into perspective, and the Working Journalists Act does that for you, for me, for people of media who want to work as journalists. A case which puts the importance of this act in perspective is K.K. Sharma versus Union of India 1998 case. This case dealt with the rights and working conditions of journalists, specifically regarding their wages and employment terms under the Working Journalists Act. This case underscored the Act's role in providing protections and benefits to journalists. Even after this Act came in 1955, in 1998, so many years later, decades later, people were still not experiencing these minimum employability conditions, and therefore K.K. Sharma had to put this case out there in the court, and this act came as a defense to reinstate the minimum benefits that the journalists should get. Now, let us come to the next section, which is the Press Council of India Act of 1978. What was the purpose of this act, and what are the functions of the Press Council that this act gave? The purpose was to establish the Press Council of India to maintain and improve the standards of newspapers and news agencies. So there has to be somebody who is looking at whatever is being published. No trash can be doled out in the name of a newspaper or a magazine. So there is PCI. This act came in 1978 because the need was felt to regulate the content which is being published. The functions of the PCI were to safeguard the freedom of press, to build a code of conduct for the journalists, and to address complaints against and by the press. The Press Council of India versus the State of West Bengal 1985 case is a good example of where PCI came into functionality and helped resolve a matter. This case involved the Press Council's intervention in issues related to journalistic standards and ethics. It illustrated the Council's role in maintaining journalistic integrity and the functions it performs in holding the ethical standards. I will take you further to the Press Council of India. The Press Council was given powers to censor. Now, what are these powers to censor? How are they enforced? What is the impact? Censoring authority. So, PCI has the power to censor any newspaper or journalist that breaches the journalistic ethics. This is not a judiciary body. It is a body about regulations and ethics. So sometimes people criticize and say, okay, Press Council of India is a tiger without teeth, because unless you have that power of law in your hand, who will listen to you? But I personally feel that these criticisms, one side, PCI has a very large role to play in censoring and enforcements. Decisions are binding and they must be published by the offending party. Whatever PCI rules against you, sometimes if as a journalist you've written something that the Press Council of India tells you, okay, this is wrong, you shouldn't have done it, and that decision is binding upon you as a journalist, and you are liable to publish it in your newspaper, magazine or publication. The impact is that the PCI Act of 1978 established the Press Council of India, which acts as a deterrent against unethical journalistic practices. The community of journalists do regard, respect and abide by the PCI decisions. One example to give this is Press Council of India versus M.J. Akbar case of 1998. This case involved the Press Council exercising its power to censor a publication for unethical practices. It demonstrated the Council's authority to enforce standards and impose sanctions on media entities. Please go ahead and read about this very, very interesting case. You would know whether PCI is actually a tiger without teeth or PCI has these powers even without law. It is still a powerful body. This is for you to decide. I'll leave it to you to ponder over, to discuss, to research, to read about, and then form your opinion. Next, we come to something called ombudsman. What is the need of ombudsman? An ombudsman is an independent official appointed to investigate and address complaints against public authorities or administrative actions. This word originated in Sweden. The term means representative or agent in Swedish. The need is of accountability, redressal, fairness, accessibility. To elaborate, An ombudsman ensures that government and administrative actions are transparent and accountable. It provides the mechanism for individuals to seek redressal for grievances related to public administration. It also ensures fairness. It promotes fairness and prevents abuse of power while one is in the public institutions. And it also leads to accessibility. How? Ombudsman offers an accessible and informed avenue for citizens to address their concerns without going through formal legal procedures. Why ombudsman? Role, purpose and trust building. The role is it is an independent mediator between the public and the media. So this independent mediator cannot take sides. They are appointed independently. They do not belong to the state. They are not from the media. As we said in the definition, it is an independent official who is appointed to investigate and address the complaints against public authorities. So the purpose is to address the complaints either about media content or media conduct. And this leads to enhancing of the public trust in media by providing accountability. One of the cases where the importance of ombudsman comes to light is India Today versus the state of Maharashtra case of 2001. This case highlighted the need for an ombudsman to address grievances against media organization, ensuring fair handling of complaints related to media practices and accountability. One objective person out there. So there are two parties with diverse opinions and they do not agree, they are fighting, they are quarreling or they are going to the court on something. So there is this objective person. Now, how much of objectivity is subjectivity, how much of subjectivity is objectivity, these are debates of a different day and you can have your opinions on them. But the functions of ombudsman are very, very necessary and they have been proved time and again by different cases. Let me tell you certain functions and then a case to put this point in perspective. Complaint resolution. So investigates and resolves public complaints against media persons, ethical oversights. Ombudsman ensures media outlets adhere to ethical standards. Public engagement. It engages with the public to educate about media ethics and standards. So as public, you ought to know where you can ask them to stop, where you can complain against them, what you can expect from them. So all this public engagement is also ensured by ombudsman. And the case that highlights this is the Hindu versus the state of Tamil Nadu case of 2006. Do you see Indian Express versus Times of India versus Hindu versus Outlook versus, all these are publications and somewhere some people or somewhere the state has gone on to the court against them. So the Hindu, which is a famous newspaper, versus the state of Tamil Nadu 2006 case demonstrated the ombudsman's role in investigating complaints about media conduct and providing resolutions, showcasing the functions in maintaining fairness and transparency. With this, let's come to an important section of laws of India. So our next sections will deal with IPC and CPC. Let's begin with Indian Penal Code, which is IPC. How do you define Indian Penal Code? It was enacted in 1860. It is a comprehensive code intended to cover all substantive aspects of criminal law in India. What is the purpose of IPC? IPC defines various crimes and prescribes punishments for those crimes. It aims to establish a clear and uniform standard for criminal justice. Some of the key sections that you and me should know are section 299, which defines culpable homicide, section 376, which addresses the crime of rape, section 420, which covers cheating and dishonesty, including delivery of property. So as journal citizens, we usually refer to these sections. We do know section 420, section 376, section 299. Now, what is the importance of actually IPC? The IPC provides a framework for the legal process, ensuring justice and maintaining public order by addressing criminal behavior and assigning appropriate penalties. That brings me to the second procedural code that we have, which is the Criminal Procedure Code, CRPC. IPC and CRPC together form a very important part of something that as citizens and as journalists we must be aware of. To define CPRC, I would say the Criminal Procedures Code was enacted in 1973. It provides the procedures for administration of criminal law in India. The purpose of CRPC is that it outlines the process for the investigation, prosecution and trial of criminals offences, ensuring that justice is administered fairly and effectively. The key sections that we must usually know is section 154, which relates to the recording of first information report, that is FIR. Section 167 that deals with the procedure when the police cannot complete the investigation within 24 hours. And section 437 that covers the provisions related to bail. So these are the journal sections which citizens usually read about in the newspapers. Whenever some reporting is done, these sections are frequently referred to. The importance of CRPC or CPC, it lies in that this code ensures the criminal justice system functions smoothly. This code provides detailed procedures for handling criminal cases for investigation and trial. So, if we were to look at certain important cases of CPC, CRPC, IPC as journalists, so 2 or 3 sections I would discuss with you and cases pertaining to these sections. The first one I would say is section 124A of IPC. Let me define and put the implications of this section. As definition, I can say section 124A is the section related to sedition. It punishes any person who attempts to bring hatred or contempt or excites dissatisfaction towards the government. So, if something against the government is put by any person, then you can be, challenged under this section. The implication is this section affects the balance between the speech and national security. So, when as a journalist or as a citizen you are tempted to say something against the government that would entice riots or that would put the integrity, sovereignty or security of your country at stake, please remember section 124A, where you can be sedated or punished if you do any such thing. So, in the name of freedom of speech and expression, these are the limits that are put to you. A case to put this in perspective is Kedarnath Singh versus State of Bihar case of 1962. This landmark case involved charges of sedition under section 124A. The Supreme Court upheld the constitutionality of the sedition law, but it emphasized the need for it to be applied in a manner consistent with the protection of free speech. The court gave a landmark judgment where it honored the right of free speech, but it also put you in punishment if this was being compromised under section 124A. Go ahead and read the case, find it interesting, discuss it with your friends. Let me come to the next section, which is section 153A of IPC. To define it, section 153 of IPC promotes enmity between different groups on grounds of religion, race, place of birth, residence, language. So, wherever you are born, whatever caste, creed, religion or place you are, you should still be amicable towards each other. So, if somebody does something to hinder this amicability, then the person can be charged under section 153A. The implication lies in preventing incitement to violence and ensuring communal harmony. Now, you would ask me, ma'am, is there a case that we can understand this act better? Yes. Ravi Kumar versus Union of India case of 2014. This case focused on charges under the section 153A related to promoting enmity between different groups. It highlighted the application of this section in addressing hate speech and ensuring communal harmony. And friends, with the coming of social media, with this non-gate kept content where there is no gatekeeping, where there is no editing, anybody can publish and print anything, this Act 153A becomes all the more important, where you can put up a YouTube video about your religious views and you might not realize, or you might realize what you're doing, you might hurt some other religious group, the sentiments of some other person following a different religion than yours. How much of this is permissible? how much of freedom of speech can you exercise and maybe entice riots or violence. So then people are, even on the new media, they are booked under section 153A. I would come up to the professional bodies for journalists in India. I'll just name some of the bodies that protect the journalistic ethics codes and the journalistic provisions. Press Club of India, which is PCI. So the Press Club of India is a prominent organization representing journalists and media professionals, providing a platform for discussion, networking and advocating of press freedom. Then there is Editors Guild of India, which focuses on the welfare of editors and journalists, upholding high standards of journalism and advocating for freedom of press. Indian Journalistic Union, this represents journalists across India working for their rights, better working conditions and fair wages. National Union of Journalists of India, then Broadcast Editors Association of India, Journalists Forum of Assam. These are examples of some of the professional bodies in journalism that represent journalists, editors working in television, radio, in print and ensuring their rights and responsibilities. These organizations play a crucial role in supporting journalists, advocating for their rights and maintaining ethical standards in their profession. Two of the major professional organizations which are put in your unit are All India Newspapers Editors Conference, the purpose remaining to represent the interests of the journalists, and the Indian Newspaper Society, which is INS, which functions to promote and protect the interests of its members. One case where the Editors Guilds of India versus Union of India, case of 2013, this case involved Editors Guild advocating for journalistic freedom and ethical practices, demonstrating the role of the professional bodies in supporting journalism and in enforcing media ethics. Friends, with this, let me recap the key points that we studied today. We looked at the need of media laws, ensuring accountability, protecting rights, maintaining standards. The major areas that we saw today were Press and Registration of Books Act, Working Journalists Act, Press Council of India Act. We also looked at some of the regulatory bodies like Press Council of India, Ombudsman, professional bodies like AINIC and INS. We saw legal provisions, which is IPC section 124A, 153A, and we also looked at the ongoing relevance, which is the commitment to these acts through certain cases. We discussed these points. To sum up, I would say it can be said that it is necessary for media persons to know about the important provisions of some laws so that they know about IPC, CPC, the sections which actually give them freedoms and which also curb their journalistic freedom at times. Although India has statutory press council, the need for media council has also been explained, and it has always been advocated that we should have a media council and maybe a separate section for media laws. But till that happens, we have to make do with these laws and how they imply and apply to us as journalists. With this, I would wind up today's unit, which was Unit 7, which was the third unit of Block 2, MJM 025, Media Ethics and Laws. I am winding up this video again with the caution that this is not a know-it-all. Go out, research, read the books, research the internet, go through the study material that we have provided you, and altogether you will have more knowledge. You will enjoy reading this subject. With that enjoyable reading, this is Padmini Jain signing off for today. All the best.